Hello, I'm Beth King-Smith and I'm here today with my colleague Caroline Cowley. We are part of the Disputed Wills, Trusts and Estates team, and we're here today to have a bit of a conversation together and hopefully answer some of the common questions that clients ask us. So Caroline, what do clients tend to come to us and ask?
We get asked regularly about how a will can be challenged. We also get asked about estate administration and what clients can do if it's not progressing as it should. And then we also get questions from disappointed beneficiaries who haven't benefited under a will and want to know what they can do about that.
Yeah, that's right. So one of the things that we find often is sibling rivalry can be a big driver for clients coming to visit us. Often when somebody has died, it could be a parent or an uncle or a spouse, but you finding yourself in that position where perhaps your brother is an executor and you're not being told the information, then that's something that we can certainly help with. So in that situation, what would we do, Caroline?
I think the first thing, if an estate is not being progressed as it should, is to write to the executor.
Yeah.
We've got to give him a chance to respond. We've got to give them a chance to give us the information we need. If after that there's no information forthcoming, then there are alternative remedies. We can make applications to the court to force them to provide that information. But ultimately, we don't want to go to court. And Beth, what do you think in terms of when you're dealing with clients who are scared about the litigation process? Are there alternatives?
Yeah, that's a really good question that lots of clients ask us, because we understand it's a very traumatic time. Somebody's died, you're upset, you're confused, you might not actually have funds to litigate. So we find, don't we, Caroline, that probably 90% of our cases would be settled outside of the court process. And by that I mean exchanges of correspondence between solicitors and the executor and the warring parties. And quite often, actually, these cases settle at a mediation. The benefits of a mediation is that sometimes, other than being win all, lose all, so maybe you've got a 2016 will that you say should have been the correct will, but your brother's got a 2018 will and he says that should be the correct will. It's either win or lose all if you go to court. And then you've got legal fees as well. So what we find is actually mediation can be a really good way to settle that dispute without going to court, so that perhaps everybody gets something, which is a compromised position, but often much more preferable than going to court. So have you had a mediation recently, Caroline, you could tell us about?
I have actually. I have had a mediation, and it was a challenge to a validity of a will.
Yeah.
And so ultimately, as you say, Beth, had that gone to court, it would be one will or the other. But we managed to find a situation whereby all the parties who would benefit under both wills were able to get something out of the estate. It was a less stressful, it was a lot cheaper, and it was done a lot more quickly, rather than having to wait for litigation, which can take months, sometimes years. So all in all, it was the best way to proceed in this particular case.
I found that sometimes with family disputes and perhaps where there's a business in the family, here we're in the 3 counties predominantly, we have quite a lot of farming clients. And sometimes where there's a death in a farming family, emotions can be running very high and you still have the business to run. So a mediation, certainly in farming cases, can be a really effective way to resolve the dispute so that the farm can continue to trade. And that's another factor that we see. And one of the things, Caroline, we've been seeing quite a lot of is challenge because of undue influence. Perhaps you could tell us a bit more about that.
To challenge a will that was procured by undue influence is a really difficult claim to succeed with. And what you're saying effectively is that the testator, the person who was making the will, only made the will that they did because somebody had unduly influenced them into making that will. And in order to succeed with that, you really need to show that there was no other possible explanation for the will being made in those terms. So from our side, it requires a lot of investigation, doesn't it? So we need to look at medical records to see whether the testator was vulnerable to influence. We look at the will file, the circumstances in which the will was made. And then we try and piece a picture together of what actually happened. Often, there can be an alternative explanation as to simply there was a falling out in the family. But as you say, those kind of claims have increased, but they're really difficult to prove.
Yeah, they are. So that unfortunately is on the rise, and that inter-family problems with often second wives versus the children from the first marriage. We see quite a lot of that, Caroline, don't we? Where people are very upset that daddy, say, has left everything to his second wife and nothing to the first children.
It is really difficult because, again, 75 Act claims really boil down to money, don't they? I mean, there's a lot of emotion involved, but ultimately, at the end of the day, you have to say, this is what you want. It's an award, it's a financial award. What an adult child has to show, though, is that they need the money. They can't just say, I'm annoyed with my parents for not benefiting me under a will. They need to show that they don't have the financial needs to maintain their daily life, and therefore they need an award from the estate. It can be difficult. You need to gather a lot of evidence.
Yeah, I think that's right. Where we find it perhaps slightly easier is if you are a spouse or you've been living with somebody who dies, and let's say you were living with somebody for 10 or 15 years and you enjoyed a certain lifestyle together and they paid for your house, and then when they die you realise that you're not left in their will. So it could be an example where, say, your second husband dies, you've been married for, 15 or 20 years, and your second husband has left everything to his first children. If you find yourself in that position, then that is certainly something where we would say the law would step in and help you. That situation where you're a spouse or a partner, then you could seek to go to court or certainly do a letter of claim to the executors and say, hold on, that's not fair, that's not right. I shouldn't be left destitute, and all the money shouldn't be going to the children. So that's something else we do see quite a lot of. But lots of the problems we see, I think, could be resolved if people perhaps put their affairs in order sooner than later. But we know that that doesn't always happen. And in that case, we're certainly very happy to help if you do find yourself in a difficult position.